Hi everyone, let's discuss the impact of a finding of inadmissibility on those in Canada. Inadmissibility means that a person has been found to be inadmissible. They are barred from entering Canada. But what if the person is already in Canada? What would the impact of inadmissibility be in that case? So remember that for purposes of inadmissibility, foreign nationals, being people in Canada who are not citizens or permanent residents, are treated differently than permanent residents and citizens. Citizens are not inadmissible to Canada, full stop. By virtue of your citizenship, you are entitled to reside in Canada, and committing a crime does not jeopardize your status as a citizen. However, foreign nationals have no protected right to stay in Canada. In fact, it's nearly the opposite. They require authorization to enter Canada and to engage in activities such as studying, working, or being a tourist. One criminal conviction for any hybrid offense under an Act of Parliament, even if the Crown decides to proceed summarily, will render the foreign national inadmissible for either general or serious criminality, depending on the crime committed, and they will be subject to potential deportation. Permanent residents do not have a constitutional right to stay in Canada, and they actually have a limited right to enter and remain in Canada. Permanent residents are not inadmissible for committing crimes of general criminality, but they can be found inadmissible for serious criminality. If you haven't already done so, I highly recommend watching our videos on general and serious criminality to understand those concepts a bit better. If a foreign national or permanent resident living in Canada is found to be inadmissible on grounds of serious criminality, they can be removed from Canada. In other words, deported. This can be an incredibly scary and traumatizing reality to face, especially if they have lived in Canada for most of their lives, or if they have a family who would be affected if they were deported from the country. You're probably thinking to yourself right now, surely you can appeal. Where's the due process? That is a great question. Now, as a rule, permanent residents who are inadmissible on grounds of serious criminality have no appeal rights if they've been sentenced in Canada to prison for 6 months or more, or if the crime was committed outside of Canada. This means that individuals may be removed from Canada without regard to their unique circumstances, such as living nearly their entire life in Canada and having no family or other connections in their country of birth. Sometimes sentencing judges will take this into account when making their sentencing decisions. We are regularly hired to write legal opinions on the impact that convictions have on immigration status so that the Crown and judge can bear this in mind when making sentencing recommendations. Remember, two of the fundamental principles of sentencing are proportionality and ensuring similar crimes committed in similar circumstances are punished equally. If a collateral consequence of an immigration sentence is deportation, that may be an unintended and proportionately harsh consequence that the person is facing. So what's the process look like for a permanent resident dealing with criminal inadmissibility for serious criminality? First, CBSA will send a procedural fairness letter to the person. This procedural fairness letter informs the permanent resident of a possible finding of inadmissibility and offers them the opportunity to make submissions to respond to the allegations. The permanent resident may make submissions arguing that CBSA should not proceed. At this stage, CBSA has two options. First, the officer may review the submissions and decide not to proceed, or the officer will initiate the inadmissibility process by writing what's called a Section 44 report. If the officer chooses to write the Section 44 report, the next decision maker is the Immigration Division of the Immigration and Refugee Board. As part of due process, they will hold an admissibility hearing to determine whether they meet the definition of serious criminality. At this admissibility hearing, humanitarian and compassionate factors may not be considered. As a result of this hearing, they may decide that the permanent resident is not inadmissible, or that they are inadmissible and a removal order is issued. There are no appeal rights if they were sentenced in Canada to prison for 6 months or more, or if the crime was committed outside of Canada. Sorry, my cat's being really loud. Now, in cases where the permanent resident was sentenced to less than 6 months imprisonment in Canada, the right to appeal exists. The appeal is heard by the Immigration Appeal Division of the IRB. Now, at this hearing, humanitarian and compassionate factors can be considered. So the RIBIC factors, as they're called, are considered as part of this assessment. Ultimately, this hearing has 3 possible outcomes. First, they set aside the removal order, which is the best case scenario. Second, the IAD can impose a stay of removal for a period with conditions. This effectively means pausing the removal order, provided the person abides by the conditions. This is a way for the IAD to test your sincerity towards maintaining a life away from criminality. Or third, they confirm the removal order. I hope that this video reinforces one key point for you. If you are a foreign national or a permanent resident and you are criminally charged or you are considering accepting a plea deal, you must seek a legal opinion on the immigration consequences